Hi, I'm Brent Van Deysen. As an elder law attorney, my law firm is dedicated to helping seniors protect their property and their life savings from the high cost of nursing home care. My law firm helps seniors qualify for governmental benefits to pay for nursing home care, in-home care, and assisted living care. We can ensure that your life savings will benefit you and your loved ones, not the nursing home or the government. Call for a free consultation at 304-594-1900.
Hello and welcome to Network West Virginia's Legally Speaking. This program is designed to educate and inform you, our local viewers, about the legal practice in our great state and how the law can affect you. Each week on Network West Virginia's Legally Speaking, we will feature some of the most progressive attorneys in the state, and you'll hear direct from them on a wide range of issues. You'll also be able to ask questions and make comments for future episodes by using the Contact Us page on networkwestvirginia.com. You can also find us on Twitter at NetworkWV. And now the host of Network West Virginia's Legally Speaking, Amy Strobel.
Good evening, everyone, and welcome to Legally Speaking on Network West Virginia. I'm Amy Strobel, joined by Brent Van Deysen of the Van Deysen Law Office. And tonight we're going to discuss some very important legal issues you or maybe a loved one will need to know about as you age. Brent, welcome.
Oh, thank you, Amy. Glad to be here.
We're glad you're back. And as we mentioned on some previous shows, your legal specialty is elder care law. Can you just give us a brief description of what that means?
Sure. Basically, as an elder law attorney, my specialty has a focus on providing legal services to the elderly. So some of the things that we do, we help people through the Medicaid application process if they're going into a nursing home, but we also do some other things like some of the planning that's important, like wills, powers of attorney. You know, planning for death is something that many people do. Not everybody, but
Sure.
many. But the one thing that many people overlook is planning for disability. So I hope to talk about planning for death and disability during the segment today.
Well, let's do that. Let's break it down. You mentioned two things, disability and death. Which would you like to talk about first?
Let's talk about planning for the end of life, and I'll use the D word and say death, because, you know, it's not something that many people want to face.
Sure.
Because, you know, we are all going to be there at some point. When it comes to planning for death, most folks know that the document to do that is called a last will and testament. Interestingly enough, if you don't have a last will and testament, our state legislature has done one for you. It's called...
Oh, great. I'm sure most people will be happy with it.
It's called the Laws of Intestate Succession. It may or may not mirror what your intentions would be, but we can talk about wills and such.
Okay, so let's do that. Let's start out. What does everyone need to know, really no matter what their age? Because I'm guessing you should have a will as soon as you really have anything to protect, whether it be financial or children. But what do people, when do they need to come see you?
Sure.
And what do they need to know?
Well, especially for seniors, I find a lot of seniors have procrastinated during their work life. Once they get to retirement, and you know, their children are grown and out of the house, and they may have grandchildren, and they may have desires to, you know, pass on the things that they've accumulated during their lifetime. And they may have desires to not only pass on gifts to their children, but perhaps their grandchildren, or even perhaps a charity or a church, things along those lines. So if you are going to create a last will and testament, it gives you the ability to have control over the ultimate disposition of the things you've accumulated, and I think that's pretty powerful.
Absolutely, because as you just mentioned, if you don't have a will, it sounds like a document drawn up by the state legislature will decide where your possessions go.
Right, and
so
that's
quickly tell us about that. I'm
Sure.
curious, where would our things go?
Well, that is our intestate succession laws,
Okay.
and it's found in Chapter 42 of the West Virginia Code, and it basically says, if I die without a will, then the law says I have certain heirs. So if I'm not married and I don't have any children, then the things that I die with will go to my parents if they're alive. If they're not, it'll go out to my siblings if they're alive. And if they're not, down to their kids.
Okay.
And then if you're married, everything will go to your spouse unless you have children from a different relationship. And this is the thing that gets many people. If that is the case, then the surviving spouse takes a portion, and your child, not from the spouse, takes a different portion.
Okay.
So it's a splitting of the estate, and your intention might be to pass everything to your spouse. So
Sure.
it could be quite a shock for the surviving spouse who's expecting that their life is going to continue on just as they had thought that it would in the eventuality that the other spouse died.
Well, what I keep thinking is you're probably so emotional, you're grieving the loss of a loved one, and now you have the stress of finding out what you thought was going to happen isn't.
Right,
so that's why you need a will.
Right, and sharing your estate with a stepchild, may be something you want to do. It may not be something you want to do. The good news is you can plan around that
All right,
possibility.
so how does somebody plan? Do they need to see an attorney? Can you do this online? What do you need to do?
I mean, certainly online you can find forms to do wills. Probably one of the most overlooked process in creating a last will and testament is what I call the estate planning process, because yes, a will is the document that will cause your estate to pass to known heirs. But if you create this will expecting that everything you have is going to, let's say, go to a spouse, but yet you have accounts that are set up that name children as pay-on-death beneficiaries, or if you have a life insurance policy where you've named a grandparent as a beneficiary or a brother as a beneficiary, even if your will says, I leave everything to my spouse, those account relationships control over what the will says. So sometimes people will create a last will and testament thinking that it's going to take care of everything, but they don't realize that the account relationships they have with other people might frustrate those wishes.
Wow. All right, what else do people need to know? Because as I hear you talk about it, it makes me realize why you need to go see an elder care attorney who really specializes in these topics.
Sure. Creating a will can be a mechanism to promote harmony in the family, and you can use this as a tool to make sure that good relationships are preserved, or if there are poor relationships between beneficiaries, you can use the will as a tool to try to keep conflict from arising. Doing that involves several steps. One of them is appointing an executor of the estate. That is the person who would handle wrapping up the estate, using the assets to pay any outstanding bills, then distributing those assets to the beneficiaries. If you don't have the right person as the executor, and if you wind up with trouble between beneficiaries, perhaps a squabble over who's going to get the salt shaker and who's going to get the pepper shaker, which really isn't about the stuff, it's about poor feelings that they have for one another. But if you don't have the right executor, if you don't have the right document in place, your heirs may wind up with the ability to fight over the stuff.
Sure.
Instead of just peacefully being able to divide things up.
Gosh, in addition to your law degree, do you ever feel like you need a therapist degree or a psychology degree?
Well, I mean, certainly over the years, it's a shame to say, I have seen the worst of people come out after the death of a parent, and siblings will literally fight over, every last thing, the salt shaker or the pepper shaker, which has nothing to do with the stuff. It's just they realize that for whatever reason, and maybe they're the giver, or maybe they're on the receiving end, or maybe they're on the giving end of the bad feelings, but everybody kind of realizes, hey, this is the last hurrah, because once this estate is over, we probably would never have contact with each other. So it is tough. And in some ways, what's worse is when you have children who all get along with each other, and then the death of the parent sparks something a perception of unfairness. And so you want to make sure that a will is created specifically to avoid that. And if there's blended families, that it makes it even more difficult because, especially if you have, a married couple and they have children from previous relationships, if their intention is, to try to treat all the children fairly, well, when the first spouse dies, if everything's going to the surviving spouse, then there's the temptation for that surviving spouse, perhaps, to cut her stepchildren out.
Absolutely. And again, all reasons why you need a will. I hope everyone will stay with us. We're going to talk more about wills in just a moment. Thanks.
Hi, I'm Brent Van Deysen. As an elder law attorney, my law firm is dedicated to helping seniors protect their property and their life savings from the high cost of nursing home care. My law firm helps seniors qualify for governmental benefits to pay for nursing home care, in-home care, and assisted living care. We can ensure that your life savings will benefit you and your loved ones, not the nursing home or the government. Call for a free consultation at 304-594-1900.
Welcome back to Legally Speaking, everyone. I'm here with Brent Van Deysen from the Van Deysen Law Office tonight. Welcome back.
Thank you.
And we just spent the first part of the show talking about wills and why they're so important as you face, death, end of life. Now let's talk about a document that would help you out with incapacity.
Sure.
And you're going to tell us all about that.
Sure. So the most overlooked thing that I see in my legal practice as an elder law attorney is people fail to plan for incapacity. So there's a series of documents that you could have, often referred to as a power of attorney. Most people have heard of that word.
Sure.
So planning for incapacity, if you think about it, and for elderly people, the possibilities are fairly significant. Planning for what if I have a stroke and I'm unable to communicate? What if I fall, hit my head, and I'm in a coma for a period of time? There's all sorts of potential situations that could come up, Alzheimer's or dementia, where you slowly fade away and lose the ability to make decisions for yourself. So basically there's two groups of decisions that we want to focus on, making medical decisions and making financial decisions. So for making financial decisions, the document is often referred to as a general power of attorney. Often it's also referred to as a durable power of attorney. The idea behind and I'll just generically call it a general power of attorney, is with this document, you can appoint somebody to handle your financial and legal affairs. Now, this is a very powerful document because you envision the need for somebody to step into your shoes, have access to your accounts, pay your bills, and under extreme circumstances, maybe even sell your home, access retirement accounts. Think about it. If you suddenly became incapable of doing those things, there are many things that you may own by yourself that nobody else is a joint owner of.
Sure, but this already sounds a little scary. I mean, it would be a little intimidating to come in to see you and then pick that person.
Right.
Do you find people are comfortable making these decisions, or is it a tough process?
I mean, it's certainly a tough process because you've got to envision at some point in your life giving up control over these things, potentially, if this event arises. Sure. And many people might feel very comfortable naming somebody as their power of attorney agent. Usually that's because of a close family relationship, maybe a child, maybe a spouse, maybe a sibling. But yes, there is the potential here for abuse. If the person you've appointed, you've essentially given them technically the keys to the castle.
Absolutely.
And if they had bad intentions, they could essentially remove assets from your estate and abscond with those. Now, Often I see a general power of attorney for financial and legal affairs being the one thing that most people are missing. And if you suddenly become incapable of doing these things for yourself, even if you can still write your name, if you can't understand what you're signing,
Sure.
it's too late. And if it's too late, you're stuck with a court proceeding for guardianship, which we'll talk about in an upcoming episode.
Okay, but that's really relinquishing control. So we talk about as life goes on and you do need to give up some control, you really should have some documents in place so you control
Right.
who's going to take control for you.
And the most common situation that I see is if somebody suddenly becomes incapable of handling their affairs and they've gone into a nursing home, if they're married, you know, their spouse might need to sell their home. If they're single, now their home's going to be vacant. You know, somebody may need to step in and sell the home. Without this document, you're not able to do that.
Okay.
It also goes with accessing life insurance policies, to prepay funeral arrangements, and, you know, accessing retirement accounts. Those things are just in your individual name. Even if you're married, your spouse wouldn't have the ability to do those things absent this durable or general power of attorney document.
All right, let's talk about health issues.
Yes.
That's another one, another
Sure.
kind of scary idea. You made me in a position, you can't make your own decisions about your health care.
Right.
What do you do?
Okay, so the first thing that I would suggest would be to have a medical power of attorney, and something else to consider is called a living will. Now, these documents, you can find them at any hospital. In fact, if you've ever had an inpatient proceeding in a hospital, you have probably signed a medical power of attorney and maybe a living will. So let me explain the two. So a medical power of attorney, you would name somebody to make healthcare decisions for you if you are incapable of doing those things yourself. It can be very important who to select. If you're married, most likely you're selecting your spouse. If you have children, you better be careful who you pick, because you want to make sure that that person has the strength of character to be able to make hard decisions, and to also include other family members in on those decisions. When it comes to end-of-life wishes, then we have a document called a living will. And you will often find the living will and the medical power of attorney combined into a single document. So the living will basically is your declaration that if I'm dying, that I want to have all life-sustaining care withheld if that care is only going to prolong the dying process. Now, there are some protections in place with this document. A physician has to make this determination that medical intervention is no longer helpful and is only hindering your death. The physician does not then remove life support. The physician would then turn to the person in the medical power of attorney and ask them to approve, you know, withholding and withdrawing life-sustaining care consistent with the wishes expressed in the living will.
Now, could you do it the opposite way? Could you say, I want you to keep me alive as long as possible? So you could do that.
Yeah, you certainly could. Sometimes I see healthcare providers will have very specific things that they want and they don't want, so the document is flexible enough to allow those wishes to be incorporated in the document. But basically then for both making medical decisions, appointing somebody in the medical power of attorney, and then end-of-life decisions, you can sign a living will. And then the two of those documents together are also often referred to as healthcare directives.
All right, we're going to talk more about that, a little bit more about wills in just a moment. We hope you'll stay with us.
Hi, I'm Brent Van Deysen. As an elder law attorney, my law firm is dedicated to helping seniors protect their property and their life savings from the high cost of nursing home care. My law firm helps seniors qualify for governmental benefits to pay for nursing home care, in-home care, and assisted living care. We can ensure that your life savings will benefit you and your loved ones, not the nursing home or the government. Call for a free consultation at 304-594-1900.
Welcome back to Legally Speaking. Brent Van Deysen and I are discussing power of attorney issues and will issues tonight. And something that I'm sure comes up when your clients come to see you is, how do you pick the person or persons who will make these decisions for you? And I guess there are a lot of questions in that scenario. It's, how do you make the choice? Can you choose more than one person? And how do you counsel your clients about the best decisions?
Sure. So when it comes to who to pick, I'm often asking different questions for the medical power of attorney and the general power of attorney for finances. So when it comes to picking somebody to manage affairs under a general power of attorney, we're talking about financial and legal affairs. It's ideal to have somebody who can balance a checkbook, who pays attention to their own finances and is fairly diligent with those finances. You know, somebody who perhaps doesn't pay much attention to their finances, or somebody who lacks a commitment, might be careless. Those would be people to avoid.
To not pick.
Right.
Okay.
So with the medical power of attorney, my question often is there somebody in the family who has a healthcare background, who might be able to understand the issues that might arise better than most other people? And so that's one criteria. Another criteria that I'll often ask about is, you know, under the medical power of attorney, is there somebody who's strong enough to make the tough decisions? If there was a questionable need for surgery, or if it finally came to that end of life decision to withdraw and withhold medical care, would the person be strong enough to carry that out? Because if they're not, then the hospital is going to look to the next person in line.
Okay.
Then sometimes I'll have folks that want to maybe appoint two people to make decisions together, which, when the two appointed agree, you know, that could be wonderful because you're being all-inclusive, you know, especially in perhaps a family with two children, wanting to include both children in on the decision. But when they disagree, then we have a real problem. And if you could imagine, you know, a disagreement on the issue of, should mom or dad have surgery, and mom or dad can't make a decision for themselves. If the children are at odds and can't make a decision, then no decision is effectively what's been made.
Okay.
Then with a general power of attorney for finances, sometimes I see them drafted in such a way that will give power to one person or to both people, but either can act without the other's input. Okay. So the idea there is maybe one of them lives close by, but often goes out of the country, and so the other one could step in. Sometimes the bank or financial institution would require both to sign off on a particular transaction, even if it lists two together. So sometimes when two are listed together, it can present a situation where maybe an agreement on what the best course of action can't be made, or ultimately may result in no decision being able to be made. Now, I've been an attorney for 15 years, and during that time, I've drafted, hundreds, if not thousands, of legal documents, from wills, powers of attorney, living wills. And so it's not just the creation of the will, though. It's the thought of estate planning. When I meet with a client, we're not just talking about the document, but I'm reviewing the whole picture to see, if they want especially if we have let's say we have a single parent, they want everything to go equally to children. And we can draft a document that says that. But if the deed to the house has already been given to daughter 1, and daughter 2 is on the bank account with mom as a joint owner, and those are really the only two significant assets, then daughter 3 winds up essentially with nothing because those pass outside of probate to the beneficiaries named in the documents or the co-owners in the document.
All right, so how often when you have clients come in, and every person is different, every family is different, are there literally hundreds of different scenarios that you as an attorney are familiar with and are walking people through?
Well, sure. I mean, often you'll see some people that, at least at the initial part of the consultation, may fit into different categories. If we have a married couple, then often the focus is on a surviving spouse. If we have a person with children, then perhaps the focus is on planning for those children. If there's a child with a special need, then we do special needs trust planning for that person, because you don't want a person who's receiving governmental benefits like SSI and Medicaid to receive an inheritance directly. Otherwise, they would lose that. Yeah, so that's why,
This is why you need to call Brent, because you know, like you said, you've been doing it for 15 years. You know all these things, and those of us, average citizen, think we might know it all, but man, when it comes down to it, there are too many ifs, ands, and buts in there.
There really are.
Wow, so, okay, call Brent. As always, thank you for joining us tonight on Network West Virginia's Legally Speaking. On behalf of Brent and I, good night.
You have been watching Network West Virginia's Legally Speaking. The views expressed on this show are that of our guest attorney and not the host, sponsors, or advertisers, and should not be considered as personal legal advice. If you have a specific legal issue, please speak with an attorney in person. For more information on schedules, appearing on, or sponsoring this or any Network West Virginia show, please use the Contact Us page on networkwestvirginia.com.
Hi, I'm Brent Van Deysen. As an elder law attorney, my law firm is dedicated to helping seniors protect their property and their life savings from the high cost of nursing home care. My law firm helps seniors qualify for governmental benefits to pay for nursing home care, in-home care, and assisted living care. We can ensure that your life savings will benefit you and your loved ones, not the nursing home or the government. Call for a free consultation at 304-594-1900.